Women and Men Against Child Abuse, and attorney Angelike Charalambous join us in studio right now. I hope I got the surname right, Charalambous. But guys, thank you so much for joining us. Let's start with the statement, great day for justice for survivors. Why?
Why? Because survivors can now come at any time and open a case. But that also very importantly means that we don't force survivors to come within a 20-year time limit.
Yeah.
By that I say that we're actually acknowledging the seriousness of sexual offences. Formally, we only acknowledge the seriousness of rape and compelled rape. But we know, first of all, the long-term ramifications and the long time that it takes for survivors of sexual offences and rape to come forward is virtually the same, because the same methods are used by perpetrators. By that I mean that children fear both the perpetrator, they fear the consequences. Are they going to break up their home? What's going to happen with their father, who may be the breadwinner? They have the same shame. They may be damaged goods. How are they going to go on now? They feel guilty that maybe they were there in the room, their brother or sister wasn't, or they accepted the sweets, or they were okay to go on a horse ride, whatever it may be. So they have almost feel they're bought into their own abuse. And this takes a very long time to process. So what we are saying is we are seeing more and more adults, 35, 45, 55, even 60, coming forward now and saying, I finally feel safe. I finally have the support. I'm no longer dependent on the person that abused me, and I would like to open a case. My case is not rape. My case is various forms of sexual abuse. Yeah. But I can't do it because the law doesn't see it as seriously.
From a law perspective, if I may come to you, Angelike, we've had cases, look at the Harvey Weinstein case as well, the Bill Cosby case, where 15, 20 years later, you've got victims speaking out. But there must be a fear from the victim as well. So how do I prove this? You know, if it goes to the court of law, I mean, how do I show that this happened to me 20 years ago?
Yeah, look, I mean, I think each case is different, and for some cases there may be photographs, for some cases there may be video footage, you never know. You know, we've had that in the past, and, you know, in some of our Frankel 8 victims. Yeah. But I suppose it is true that it will be difficult to prove after 20 years, but at least now these victims have that opportunity. At least now they can go to a police station, report the charge, lay the claim, and I think even that will give them a bit of more closure. They're now saying, sorry, it's 20 years ago, you can't lay your complaint, and you just have to deal with what happened to you. Exactly.
So now the Constitutional Court has upheld, you know, the decision. What now? It goes to Parliament?
Correct.
And what happens in Parliament?
Correct. So the Constitutional Court did allow for a reading in the court order to amend the legislation currently to allow victims of sexual abuse for more than 20 years ago to still go now today and lay their claim. However, the Parliament has 24 months to change the legislation and enact it in a manner that they see fit. And if they don't do so within the 24 months given to them, then the reading in, which the Constitutional Court has allowed for in the court order, will come into a permanent state.
Okay, are you expecting Parliament to do so?
I think so. I mean, we have seen in the news that they've started trying to adopt the bill and all of that. So I think they will have an opportunity to do so in the 24 months.
Okay, Miranda, you mentioned some of the you know, the reasons why the modus operandi of, you know, the abusers and so forth. But why do you think some of the victims wait so long, even as an adult now? You know, you're not a teenager anymore.
Yeah, and I think the reality is that coming forward, first of all, disclosing causes certain ramifications even if you're older. You may have just gotten married, you may just have a child, now you have to explain everything. The child is very small, you take off time for work. You know, if I look at the whole movement that you just spoke about, if we look at the whole Me Too movement, there was a stage that nobody really believed people where the abuser was someone that was loved by the family, liked, respected, well-known, had a different power position. And so I think this also comes into effect even when you are 20 or 25 or 30. That's why I'm saying we're almost looking at the 35s to 40 who are in already, seeing what's happening around them. We saw what happened with Bob Hewitt.
Yep.
Nobody expected that. Nobody thought that he would actually eventually be brought to court and that he would be convicted. And at 76, he would go to jail, where he still is today.
Yep.
Now, that would not have happened 20 years ago, because the way people looked at, judged, victim blamed and shamed was very much the way society was. And I think we're very thankful, that things have changed.
We're talking about the court, and, this is when matters actually get to court and so forth. But obviously, I'm sure your organization must be worried about when, victims approach the police station. We've seen of late, you almost feel sorry for a person who goes to report a rape or some sort of abuse at the police station. They're not taken seriously. What are you doing to maybe conscientize or educate the police and how to handle these situations?
Well, that's a huge thing, and that's mammoth, because exactly what you're saying has been happening for 20 years or so. Even with specialized, the thing is that the specialized police services, if we look at the FCS, the Family Violence, Child Protection and Sexual Offences Unit, are not the front line at the charge office. They have to be referred. So everything has to be a little bit more specialized. So, for instance, if somebody goes to Childline or somebody manages to get an organization that will help take them to the FCS, that's a different scenario. Yeah. But just going into the charge office, we have a clinic in Alexandra on the first floor of the police station. And I can just say, if we did not have that, I cannot tell you how many children would have been turned away. And the thing is that they're not also sure what to do. They don't know how to handle it. So they have a place to send them to. But this is by no means what happens in general.
For the Frankel 8, what next now for them, Angelike? Because there's a civil case against Frankel, isn't there? How far has that gone?
Yes, correct. There is a civil case currently in the High Court of Johannesburg. We were hoping to get a trial date this year. It looks like we may be pushed to early next year for a trial date. But we've been working with the Deputy Judge President. He's been case managing the matter because it's such a big matter and it's so important for South Africa. Yeah. So we have been meeting with him and going through the process with him. And hopefully early next year we'll have a trial date. And
Is this the first of its kind? A civil case when somebody, the perpetrator, has passed on?
I think it's the first that's been taken this far.
Yeah.
There is an issue of the whole prescription on the civil side as well. So we need to get over that hurdle. And with Frankel also not being alive anymore, there's also that hurdle to get over. But I think it's going to be a very interesting case.
All right. Thank you so much, guys, and good luck. Wonderful work that you guys are doing.
Thank you very much.
All right. That was Miranda Jordan and Angelike Charalambous from the Women and Men Against Child Abuse